Crawford Lunch and Learn, a virtual experience, and very pleased to have a liability lunch and learn this afternoon. Before I kick off, I do want to acknowledge make an acknowledgement of country. And today I come to you from the Sydney CBD, which is the land of the Gadigal people of the Eora Nation. I know that many of us are on different lands today, and I acknowledge those lands as well. Chrissy's in Brisbane, John's in Melbourne. So I'd like to acknowledge the traditional owners of country throughout Australia, wherever you are, and recognise their connection to the land, waters and culture, and pay my respects to their elders past and present. Today we come to you all with, I feel, a very solid topic for discussion, and I'm really pleased to be able to introduce to you all John Stagg and Chrissy Cheeseman, both experts in their field with significant amounts of experience, but more importantly, I think, enthusiasm for our industry and what we want to achieve in relation to claims. My name is Nathan Heppel. I am the Head of Legal Services for APAC for Crawford in Australia and the Pacific region and into Asia, and also part of HBA Legal. Chrissy is our National Operations Manager for TPA. She will be known to some or many of you, and she's had almost, I think, maybe a tick over 20 years of experience, Chrissy, as an expert in not just managing claims, I think, and we'll see this today in our conversation, but also helping to manage the various service providers and stakeholders that exist across the spectrum of a claim. And also a very warm welcome and thank you to John Stagg for his time in preparing for today and being part of this presentation. John, for over a decade, has been an adjuster. Prior to that, I did comment to him earlier, on his LinkedIn profile, he has a short stint as a labourer, which ensures that he gets many wonky floor claims, timber floor claims. But John, we won't highlight that too heavily today. You're here in your capacity as Senior Liability Adjuster with Crawford Australia, and we're very proud to have you, not just as part of the team, but also here today. So I'll turn to the scenario. Just a little bit of housekeeping as I kick off. We do have a Q&A section, which I can see on the side of the screen, and I would really welcome questions. I'm going to stick to time today. I know that everyone's time is valuable, and what we want to make sure we do is run to time. We do have a backup scenario in case we run slightly ahead, but I feel that we might be able to hold that over for another occasion. And for those playing along at home, you might want to return for the next session, but we'll see how well we do today as a team, Chrissy and John, for that. But please add your questions in writing to the section on the side of the screen. And what we'll do today is, as those questions come through, if you feel that's a good question, like it, because what we'll do is when it comes time to answering questions, we'll answer in order of the questions that have been liked, because I think that's probably the fairest way to handle it rather than necessarily in order. And if we run out of time at the end, we'll make sure we get back to you. So without further ado, let me talk about the scenario that the team is going to discuss today. I am going to step in to add the legal component of the conversation in conjunction with Chrissy and John, because Nick Stanisic, who was advertised to be with us today, is in court handling some matters. So a tile coating specialist, the insured, has been engaged to strip and recoat coping stones around a swimming pool. While the insured holds itself out as expert in selecting correct chemicals and methodology for each job, they use a chemical which, when interacting with the water, forms a toxic vapour that burns human lungs. Sounds pleasant. The insured does not take steps to prevent draining into the pool. And the chemical eats the pool liner. But what's worse is that the client's 3 children end up hospitalised after swimming in the pool just a few hours later. That's quite a parent fail. The prognosis is that they'll have respiratory health issues for life. So with that in mind as our scenario today, I'm sure many of you on the call have a lot of experience in different aspects of liability claims, and there are lots of ideas popping into your head right now about how best to go forward. But Chrissy, you're the person who's going to receive this claim today, and it is hitting your desk as claims manager, let's say, in relation to the way you're going to handle this. So from my point of view, I'd like to sort of talk to you about what are your first thoughts? What steps are we going to take? And in particular, how are we going to gather evidence and make some early informed decisions around what steps to take? Because, of course, those early steps are critical. I'm sure you would agree.
Absolutely. Thanks, Nathan. When I was reading this scenario, there were just so many questions that immediately came to mind. And I think that's what often happens to us as claims managers. Something like this comes across our desk, and the immediate thing is to start sort of triggering all these questions in your mind. I think it's important to note in those sorts of circumstances is going back to absolute basics. If I can just share with some of the people online, this claim came into us, so it is sort of based off a real life scenario with, you know, some, if I can say, some embellishments, but holistically, the scenario is a live example, so to speak, and it came through with very, very little information to us, and really the insured only really shared with us that they were responsible for cleaning the tiles, not undertaking the extent of the works which subsequently has come to light. So my first port of call, Nathan, to be really honest with you, is to understand the facts and circumstances of the incident at hand. I think it's always best to pick up the phone and actually speak with the insured. In this circumstance, we didn't really have the benefit of a claim form or any letter of demand, you know, for that point, and therefore we had very little to go on in respect to the information that we had to hand. So the first port of call for me in that instance would definitely be to pick up the phone and speak with the insured and gain a better understanding of what actually occurred from their perspective, what works were performed on site, how long ago those works were actually performed, which obviously goes to the benefit of causation further down the track.
And Chrissy, just on that, because I think it's a really important point. You mentioned this scant information that comes through in this scenario. I imagine, first of all, that's quite common. But secondly, is your mode of operation with these things, even if they provide lots of information, to pick up the phone and talk to the insured early on?
Absolutely critical, because even with the benefit of information, you still may not have an accurate understanding of what the facts and circumstances of the incident and potential claim to be, Nathan. So I'm not saying that you will glean all of that information from that first interaction with the insured. That's one critical aspect. Some other critical aspects of reaching out and making that contact is controlling communication channels. So immediately you want to ensure that you have only one central point of contact in terms of interacting in relation to this claim, and ensuring that you put that into the hands of an expert that understands what to say and what not to say. No doubt I'll talk to it in a moment as well, but here we're talking about a liability claim, but we're talking that the liability claim has two different components of it. So you've got your property damage. As you said, we've got a pool liner that's eaten. We've got no doubt other remediation work which needs to take place to the pool and its surrounds as a result of this particular incident. But you've also got the personal injury claim. And while they've arisen out of the same set of facts and circumstances, the claims for a property claim and a personal injury claim need to be managed differently. And of course, we don't want the insured sharing information which may be critical to the management of our claim further down the track. So preservation of evidence is also really critical. Protecting the interests of particularly our insured that we're working on behalf of, and the underwriter for that matter, is also really critical. So it's really important to establish the expectations, to understand protocols and procedures and what needs to be done from that point forward.
And Chrissy, one of the things, can I just make an observation there that I really like about what we're exploring here is, at no point yet have we talked about JICOP, or have we talked about X number of days to respond to something, or Y. The importance of those things can't be understated within our industry. There's no doubt about that. But in these initial stage of claims, it really is good old-fashioned detective work and building trust and rapport with the insured who's reporting it to you, isn't it, in order to garner that information out of them for management of the claim, rather than necessarily being focused on, well, I have to send a letter to somebody within X number of days and I have to have a response within Y, etc. Is that something that served you well throughout your career in terms of both your own claims management experience, but also supervising teams?
Oh, absolutely, Nathan. You know, obviously that's a guiding principle, and the General Insurance Code of Practice is a guiding principle. It's what we all adhere to, and even on those clients where JICOP does not apply, we still use that as a great industry standard. But if we're doing our job well, it should all fall into order in terms of proactive management, timely communication, interactions with the insured and other key stakeholders. I have to say, my team is probably sick of hearing me say this, but I've also been guided by the principle from sort of day one in managing claims to get the best possible outcome at the earliest possible time. So one of the things that we ought not be afraid of in managing claims is understanding that sometimes the people that we're acting and our insureds that we're acting on behalf of may have done the wrong thing, whether that be intentionally, hopefully not, but also unintentionally. You know, adverse outcomes occur in the works or interactions that our insureds have. And therefore, it's really important in establishing that evidence early, Nathan, and making sure that if we have done the wrong thing, the strategy that we have on that claim just alters to make sure that, as I said, we engage the right stakeholders and get the claim settled as soon as we possibly can.
So we've talked about those things in terms of the importance of quickly speaking to the insured, gathering more evidence, not trusting necessarily every bit of material they've provided, ringing them even if it looks like a very detailed lot of information's been sent. What about communication channels? What about managing expectations? How does that fold into that initial approach for you?
Absolutely. So as I said, it's key that you don't have multiple people communicating in respect to this claim for the insured. So you don't want the insured as well as ourselves, and for that matter, if we engage experts such as loss adjusters, the loss adjusters communicating to other parties as well. So it may well be that we say it's us, we may well say it's the loss adjuster. It really, again, is led by your strategy as to how you're going to get the best possible outcome at the earliest possible time. But it is absolutely critical that you've just got that one channel of communication between the parties involved from the insured's perspective.
And obviously that then leads into your decision making about at what point you might appoint other experts to assist, because of course, from your point of view, you're managing the claim and you're going to require, in certain circumstances like this, experts to come in and help. How does that weigh into your mind? And then I might kick over to John, but how does it weigh into your mind in the sense of two things? One, when would you appoint an adjuster, say? And secondly, how do you manage that conversation with the insured to keep that chain of trust moving?
So to your first point, Nathan, I would say, as I said at the very beginning, this is a claim that has both property and personal injury components to it. And I will talk about the specific facts of this matter because in a true claims manager's opinion, each claim turns upon the facts and circumstances of the matter. And whilst we've got a plethora of strategies that are available to us as claims manager, it needs to fit the particular claim at hand. In this one, I immediately kind of go, yes, there's a property component. There's also a personal injury component to the claim. And we have 3 minors also involved in this. And as you read out in the scenario, Nathan, the other critical aspect that we do know is that they've got they're minors for a start. They've got respiratory health issues. And secondly, those health issues are for life. Those sort of, what can I say, aspects of the claim, facts of the claim are red flags to me. So my view is on a claim like this, I would strongly encourage the claims manager to make sure that they think about who or how we best execute the strategy around evidence and fact gathering. So to that point, in this instance, given the very nature and potential extent of the loss and damage, I would appoint a loss adjuster. And I think, as I said, given the criteria that I've spoken about, I would actually consider whether it's appropriate as to whether that appointment of the loss adjuster should be undertaken by a legal firm to ensure that the report that they provide to us and the work that they perform is actually privileged, just to protect the interests of both the insured and the underwriter in respect to any claim that's forthcoming.
And no doubt that's, you've got those red flags that are sitting there in terms of the long-term health effects that causes you to have that frame of mind. John, absolutely. I think that neatly comes to you in the sense of it now hits your desk. So Chrissy's rung you. Hey, John, we've got a curly one here. What goes through your mind when you get this? I mean, what are the key lines of inquiry you're following straight away when Chrissy calls you? And I think also, can I ask you too, how do you deal with an insured who is obviously already building a rapport with Chrissy and you need to now pick up that baton and run with it?
I think the second part of your question comes into picking up the phone with Chrissy to work out where she's up to already and making sure we can take over that relationship, or at least coordinate how we're going to deal with that relationship with the insured in the first instance. We also want to be careful not to be doubling up on gathering information from the insured. If it's already being received by Chrissy, we don't need to be asking the same questions again. It's really about how the adjuster can enhance the investigation process. In terms of the lines of inquiry we're going into, there's a lot of questions for the insured in this scenario. And it goes to, yes, we know they were cleaning these coping stones and they hold themselves out as experts, but how do they really present that? What advice are they giving around product selection? Is it that this is a product they've been brought by the third party and told to use? Is it something that they obtained from another party and use on site? The other side of it is what, when they're saying they're experts in selecting these products, are they thinking about the coping stones they're cleaning, or are they thinking about the coping stones they're cleaning in the context of around a swimming pool? Because we'll often talk to an insured that says, I've done this 1,000 times, this works. You go, yes, but have you done it next to a swimming pool like this? And then that leads nicely into, we're looking at the contract between themselves and the third party. Yes, it's a consumer and there's going to be some consumer guarantees at law that will come into play. But there's also a question of how much involvement the insured has in determining why this work is being done, how this work is going to be done. And then that goes to, where did they get this product from? What advice comes with this product? How is it packaged? How is it delivered to the insured? What does the insured do with it? Now, the claim that...
Can I just pause there, yep, John, as I like where you're going with this. I just want to take it back about 3 steps, though, to sort of tease out this point. We're going to have lots of folks on the call today, and I can see we've got a really decent number of attendees, which is fantastic. Some from brokers, some from insurers, some from Crawford, I hope, some from perhaps other adjusting firms who want to come along and listen to our fantastic lunch and learns. But to me, when you go out, are you thinking about indemnity? You know, at what point, and I know this is a slightly curly question in the sense of it, and I'm anticipating your response is going to be, hey, I'm agnostic to that. I'm about the facts. But can you talk that through in terms of the way you manage that when you go out to someone's house?
We do have to have indemnity in mind. Whilst we might have an insurer that says they don't want a direct comment on indemnity. The role of a loss adjuster is to put those facts into a meaningful manner for the insurer to line it up against the policy. If we haven't read that policy and understood that policy, we can't go and pick out the correct facts, or we can't be following the right lines of inquiries that are going to satisfy that insurer's questions when they look at the policy. So it used to be that we would do commentary on policy and legal liability in our reports and provide it to the insurer. We still have to approach these claims as if we're going to be asked those questions, because the way we write our report should answer the questions the insurer has. It's a messy approach to a claim to go and gather what we think the insurer needs to know without having seen the policy, and then be sent back to site or have to carry out additional investigations following our first report because we haven't clocked that there might be an endorsement that needs to be checked, whether that might relate to how they're doing their works, what safety procedures they put in place, if there's a standard condition for reasonable precautions to be taken. We're looking at what sounds like a fairly nasty chemical here, and I know with this pool it was a gel coat lined pool, and we know from all the boat claims that we do that you can acid wash gel coat. This has been eaten by this chemical after it's gone through a pool of water, so it's something fairly nasty. So we have to know if there's something in the policy that deals with handling hazardous chemicals and how they go about it, what precautions they take. We need to know the answers to those questions so that our report is useful to our client.
And I think we've got a fantastic question on there from Jeff Plumridge, and hello Jeff, because I know Jeff very well from the old Woolworths days, and it's great to see you on there, Jeff. It's directed to Chrissy, but I think this is something probably open for both of you, and maybe me to chip in. It's a great question about, would the investigations and fact finding be different if the claimant is alleging an ACL breach versus a straight negligence allegation? Now, one thing I will say, Jeff, is that you know, as usual, you're about 8 steps ahead of us, because of course I don't think the claimant's going to be there on the steps when the claim is originally made, saying, yes, but this is an ACL claim versus a negligence claim. But I do think what it highlights, of course, is this point about the fact that clients expect us as a TPA or adjusting business or legal business to be thinking about these things at the very outset of the claim, so that we're not then having to backfill later when the obvious arises, as Jeff has highlighted. So, guys, just on that theme, can you unpack that in terms of the obvious product inquiries and the obligations on a statutory basis under the ACL versus negligence?
Did you want me to start with that? Because I would say, and remembering that we're talking here in relation to the steps that you would take at the very outset. So I, as you know, Nathan, in the management of my claims, I always say we have to risk manage the way that we manage our claims. In this scenario, we don't know, Jeff, as Nathan alluded to, whether it's going to be a claim under ACL, whether it'll be negligence, and therefore it's our duty to make sure that we cover off obtaining information, facts, circumstances, investigating the claim, to ensure that basically, and I can't say every single allegation, but certainly the most common allegations that we would receive in these sorts of claims, from the knowledge and history that we have, are covered as part of those initial investigations that we undertake. So it's, we need to be on the front run in relation to the potential for a claim to arise through either of those avenues.
And John, how are you doing that? And John, how are you? Thanks, Chrissy. And John, how are you doing that when you're on site? So run us through. You turn up and you're working through the process with the insured. And when I say on site, it may well be at the insured's premises or the area where the pool happened. But because I sort of paused you earlier when you were running through this component of it, because I saw Jeff's question. But can you run us through things that you're looking at around bags, warnings, all that sort of stuff?
Well, that's it. I mean, echoing what Chrissy would say, was saying in our report when we come to look at liability, and I'll say that we carry out our investigations so that there is the information follows the same order you might put your report in as well. And in talking about liability, we are looking at tort, statute, and contract. So those discussions with the insured and with the third party is really about, okay, what have you been engaged to do here? What are the terms and conditions that you've signed up to, implied or expressed? And then we're looking at how did you do this? And in terms of the negligence side of things, this is why we're going into unraveling how the insured handles its chemicals that it's using, because there could be a negligence factor in there. By all means, we're going to look at this for when we're looking at liability. We're looking at, as Chrissy said, what's the most likely avenue this claim is going to follow, and where's it coming from. Consumer law is usually the place that a third party's going to start with. Not everyone would be thinking about contract as a resident, sorry, as a personal claim. They'll look at,
if you end up going to Jeff Plumridge's house, though, just bear that in mind, because he will be.
He's going to come for it. Well, yeah. I know the third party on this claim has actually researched a lot of her rights and what she was entitled to at law. Generally, we'd see a third party who's sitting there saying, "You've damaged my pool, fix it." Which again, a liability insurer is not going to fix that. And there's a bit of education we do with the third party around what has to happen next. But in terms of whether we change our approach, not really. It's a case of gathering all the necessary information to be able to say where the exposures are for the insured. I know with this one of the areas that was part of our investigation, we looked a bit more into the negligence side of these things and what the insured had done, because it might very well be that the third party's got them banged to rights under ACL. But another element of what we were doing on this claim was seeing that here's something that's quite a severe outcome for the individual, especially on the personal injury side for this claim. And given what the insured's business is, this should never really happen. We know it does happen, otherwise none of us would have jobs. But we're then looking at what advice can we give, or what information can we provide to the insurer on the risk profile that we're seeing through this claim. What is it that the insured's doing within their operations which might change how the insurer perceives this risk on their books? For this claim, they were decanting products into unmarked buckets and taking them to site.
And just coming to that, indeed, because I want to come to two things in the next section here, which is the bags and where they came from, and whether they were from overseas, and what the labelling showed, and various other things, and why we're looking at that. And perhaps I can chip in a little from a legal point of view there. But I also want to come to the injury component, because I think I want to bring Chrissy back in around how we handle an upset couple of parents, no doubt, who have thrown their kids into the pool only to leave them with lifelong damage to their lungs. But John, my observation of the bag question, of course, is that could well be quite a rabbit's warren that we go down, because at least my observation would, and questions I would ask from a legal point of view, are what was on the bag? Where did we buy the bag from? Who supplied it to us? Have we handled this material before? Are we qualified to be able to use it? Have we sought advice from somebody who perhaps was more qualified than us, and we relied on that advice in then using that material or that substance on the pool?
Did we engage subcontractors to actually perform the works that we were contracted to do at first instance?
Yes, indeed, because of course all of that lends itself then to identifying avenues for passing some responsibility for the ultimate cost of the claim onto another party. Because of course, if it so happens that our insured has trundled along to I'm not going to name the name, but a large retailer with big green warehouses all over the country, and bought from them with their labeling on it the particular chemical, then and that's not fit for purpose, and et cetera, then there's the potential for contribution to be sought from those people. And so when you're talking to the insured about these things, how are you weighing that up? What kind of questions are you asking them to make sure that you get the right information out of them, and it's not sort of just being designed to, allow them to walk away from responsibility?
Well, I think it all comes down to asking them how they select these products and what they. One question with this is, did you know this is what you're putting in the pool? Because if you see enough of these claims, you become aware that sometimes in those big green sheds, the label on the bucket or on the bag might not match what's inside the bag. So it's a case of, we need to get the insured's history with this product, with its distributor, what it knows about this product and how it's used it in the past. It may come from initial discussions with the insured that they say, we've done this thousands of times with this product, it's no problem. And here's the technical data sheet, here's the material safety data sheet. And you look at that and go, well, it might be that doesn't line up with the injuries and the damage that we've got. And this doesn't add up. In which case there's a whole nother ball to unravel as to what's gone on here and what's gone into the pool. And if it even does relate to the insured's work. But on the other hand, if we've got confirmation from the insured they use something that they shouldn't have, that becomes, and I know on this one we did carry out investigations with the manufacturer to see if there were limitations that they put with their products, and who their distributors are, how you can buy it, and what sort of advice is provided in conjunction with that product that should have prevented this from happening. Because whilst we are looking for avenues of recovery, we ought to be testing them at this stage so that we're not wasting time sending off letters and having material safety data sheets thrown back at us that say, look, this is a hazardous chemical, should be nowhere near water that you want to be swimming in.
Or, heaven forbid, it happening again. I mean,
Yeah.
I think this is one of the points you raised earlier, John, which is, I think it's an excellent point that's worthy of emphasis, which is that when we go out there as Crawford adjusters, yes, we're looking at the claim, but we're looking at it through also the prism of saying to either underwriters or the insureds themselves, hey, this is a problem.
Yeah.
And we can't have people going out and doing the same thing over and over again. But it does lead me to my next question, guys, which is, it's a bit of a layup, but I do want you to talk about where things go wrong when this doesn't happen. But can you talk about the importance of particularly adjusters and claims managers and claims experts working together for the same outcome at the early points of a claim, and really putting to one side who's, any notion of we're not on the same team, but rather working genuinely together? What impact can that have versus not? And I'm thinking here about the old days of, where an adjuster might receive a one-page letter saying, hey, this incident's occurred, need you to investigate it, thanks, wait to hear from you. Can you talk about the modern world where we now live of collaboration and why it is so much better?
Yeah. Can I start with that one?
Sure.
Go ahead.
Sure. I'm just about, it's always so much easier having access to the claims handler who's instructing you. Like on this one, Chrissy's talked through having already carried out some inquiries with the insured. Nothing will get an insured more annoyed with you quicker and hurt that ability to build a rapport as you asking the same questions as someone who might be from the same company as you has asked them last week or a couple of days ago. So having that person, certainly with the TPA One Crawford model there, that we're in the same business and we can pick up a Teams call and have a chat with them. But similarly, talking to the insurer's claim handler and finding out what they've achieved to date, what they've found out to date, saves a lot of time and lets us get to the right answer a lot quicker. And it may be that the claims handler at the top end has had these answers from the insured or from a third party. They might have more in terms of what the demands are, a bit of a correspondence history, and that the job of the adjuster may be to see those facts that have already come through and go and target fleshing them out and obtaining information that verifies what's been said in these conversations. If we picked up, we still do it now when we do get a letter from a legal advisor for an insurer instructing us, they'll send a letter that says everything they want. Still pick up the phone and have a chat with them about the scenario and what they already know. And I think you'll get a lot more out of having those conversations than you'll ever get from the initial instruction email.
Chrissy, your thoughts?
Oh, look, I absolutely echo what John has said, but I probably go back to one of my original points as well, is claims can't be managed by one person and one person alone if we're going to generate the best possible outcome. And to me, engaging and collaborating with a loss adjuster, an earlier point, particularly when you've got a scenario in your hands like this, so you've got a large loss or you've got a loss which is emotionally heightened, which this is going to be with parents with 3 children, it is absolutely critical to engage and collaborate with the key stakeholders. And I see loss adjusting as one of them. And as I said, I'd also see legal as one of them in this particular scenario. I just don't see how you can get the best possible outcome at the earliest possible time without working in collaboration. We all have to understand what our roles are in performing, working together to make sure that that outcome is in fact achieved, which is what we want for our insureds, and it's what we want for the underwriters that we also work on behalf of as well. And it's great that I think there's much more open lines of communication and interaction now with everyone being on the same page, but it is understanding what everyone's roles are in the collaboration piece.
Well, I was going to come to that. I mean, we've obviously picked a scenario today that can involve different experts, and I'll come to the legal component. But the thing that I am seeing more and more and more is that people need to work together, but also understand where their lane is, and to stay in their lane and support the other people who are in that different lane with information that they request, but that, you know, particularly in relation to the claims experts, you know, dare I say it, I hope there aren't too many lawyers on the call. But the thing about it is, once you get lawyers involved in those things, of course, that they will, you know, be involved in the sense of analysing the information that you've already obtained, but they're not an expert that you put in front of the insured. They're not an expert you put in front of the claimant necessarily at the first stages. That is something that needs to be reserved for the claims experts, and in conjunction with the adjusters. So to me, Chrissy, I think it's absolutely critical in 2023 and beyond that we do rely on the expertise that we've got and allow people to stay in their lane. But just on that, I think it opens it up. I mean, in terms of this scenario, yes, we did select it because it does involve some curly questions, and I want to come to the injury component. But do you know, this is not for every claim, because we mustn't involve lawyers in every claim. We need to use that sparingly because it can be expensive. Why in this claim though? Why do we involve lawyers in this claim? What is it about it that causes you both to say, do you know what? We really should have some legal privilege over this and get some early advice.
I'm happy to jump in and start the response to that, John, if you'd like. As I said, for me, Nathan, it comes down to a few different points. The fact that, as I said, to me, it's got red flags on it, that you've got, in particular, you know, property damage is property damage. It can be remediated, but you've got 3 minors here who have, you know, serious respiratory health issues, and the prognosis is that they're going to be for life. You know, even for preservation of evidence, given the fact that the statute of limitation in personal injury will run for them for a significant period, because they'll have 3 years after the age of becoming an adult at 18. So you've got a long period of time. You're also dealing with, you know, probably highly emotive parents, and not that, and understandably, and not that that would necessarily be a direct point of engaging lawyers, but you need to make sure, as I said, that you have the benefit of all the evidence that you possibly can to manage that situation at the earliest possible time that you can, and to protect the interests of the insured and the underwriter. So for me, as I said, I truly believe in what you've just said is that from a claims management perspective, I don't think that lawyers need to be involved in each and every claim, and for that matter, you know, if you do brief a loss adjuster, that privilege is set out, or the instructions come from a legal panel to protect the privilege over any report from the loss adjuster. But I think it needs to be a consideration of any claim, and where you've got red flags like this one does, I would definitely put that in my serious consideration for a claim to be managed.
Well, and before I come to John on that, if I can just add in the legal component very quickly. I mean, the things that jump out to me in relation to this matter are consideration of the policy and whether indemnity should be extended here. Because depending on the wording of the policy, depending on any sublimits or deductibles, or even circumstances that in terms of the level of coverage provided to that particular business come to my mind. And so all too often we see insureds where they'll describe to underwriters that their business is pool cleaning, for example, but they don't elaborate to include the house cleaning and pavements and using caustic chemicals to do so, which would cause underwriters to put the level of risk into a different category, et cetera, et cetera. So those things are in my mind initially in terms of what I'm trying to get teased out by John and you, Chrissy.
Absolutely.
The other thing that's at the top of my mind, of course, is these children and dealing with that sensitively. Things like ambulance notes. I mean, I'm very, very fond of saying to junior lawyers who I'm training, when the ambulance turns up and the paramedic says what happened, people tend not to make it up. It's one of those truth moments in life, isn't it? When the ambulance turns up and says, have you got any pre-existing conditions? What happened here? People tend to give their reaction. And I think that kind of highly contemporaneous material allows for an accurate snapshot. And it's important to gather that stuff early on. So I'd be seeking that out. But importantly, the other thing I'd be seeking to do early on is make a realistic assessment of the reserve. Because again, all too often we see on the face of it what might be quite serious and nasty injuries, but which don't necessarily need a large reserve on them. As I'm sure everyone on this call has different stories about how to reserve, but it is the Goldilocks theory. Not too hot, not too cold. We've got to get the temperature just right. And to me, I would always be approaching reserve with a level and cool head to say, well, what should we be putting on this for now? Equally, I've seen minor incidents, not as in child minor, but what could be perceived as small incidents turn into large claims, and the reserving has to be considered carefully. So that's the other thing that's on my mind. And just finally, recovery. I think that's a critical component of what lawyers should be adding, which is not to sit back and wait and think, oh, well, we'll just have to wait because we'll have to wait for these kids to turn 18 and then we'll see what happens, and on it goes. In this environment where we are now, notice is critical. And I think that it's really important to gather this evidence and put on notice whoever the other party is that we want to point the finger at early on, so that can be sorted out. Now, it may well still be that there's a dispute over it. It may well still be that we end up as two discrete defendants in an action in the Supreme Court or the District Court. Of course, but that's going to happen in relation to claims. But it is a lot more comforting to be able to turn up to court and know that we've got letters that date back 14 years, which put the other party on notice when the judge says, yeah, I kind of agree with what was said 14 years ago. That makes sense. But importantly, that was contemporaneous with the time, and it has a much stronger ring of truth about it. So my encouragement to people, whether I'm briefed or not, this is a lunch and learn. This is all, advice to the industry, and we love doing it. Is to say, be careful with holding back information in relation to recoveries that you know are going to occur, because I do think that it'll end up being worse off. John,
No.
I know sorry, Chrissy, go ahead.
Oh, I was just going to say, Nathan, one of the other points that we haven't touched on in relation to this, and I suppose John did talk about it or touch on it slightly when he talked about instruction about use of the chemicals and, you know, how often they've been used before, what the instructions were. One point that we haven't canvassed and considered, but very much came to me when I was thinking about this particular scenario too, is did our insured depart the scene of performing this works, providing instructions to the owners of the property and obviously users of the pool as to anything around, you know, how long between the work's being performed and they can swim, because obviously there has been the use of chemicals in performing these works. You know, were the parents in fact told not to allow anyone to swim in the pool for a period of time as well? They haven't obeyed those instructions and let the kids jump in, and that's what's also led to, or at least contributed to, the injuries to these children as well. So, you know, it may not even be, you know, the work that we've performed, the work that, you know, any subcontractors or contractors that we utilise, all those sorts of things. It could actually have been, as I said, as a minimum contributed to by the action or inaction of the actual owners of the property as well.
Well, I mean, that's experience shining through there, Chrissy, and you know, I think absolutely spot on in the sense of asking the question, well, was this even us? There might have been a gardener who arrived a little later in the day before everyone arrived home from school, and they've dropped fertilizer in the pool, and that's had the same effect, and they've left.
Or a pool valet.
A pool valet has turned up on the same day because without letting the parents know, and that they've put it in, and so it's those sorts of things that are really, really critical. John, just coming back to you, so we've, you know, got the expertise in terms of claims management, legal. Any other aspects of things that you can consider might come into play with a claim like this?
Something like this would involve, I think, drawing on both other parts of the One Crawford team. So mainly I'd be thinking CRD, who's our building consultants. This is more to the property damage side of it. Not looking so much at cause, but looking at how do you fix this? Being a gel coat liner, I know this pool that we've based this scenario off of needed to be removed and lifted out over a house and then replaced with a new shell. We'd get CRD involved. They've got QSs and building consultants who can give a view on the most economical way to do that, whether the third party's costs are reasonable and what they're looking to do. Other side of it, maybe on the more personal injury side, you might involve our forensic accounting team to look at how we quantify these losses that are being demanded. It might be, and I know I've seen personal injury claims where a minor's involved and the parent will have a view on what enjoyment of life is worth, and it's they may not even be able to put a price tag on that, and who could?
Accountants.
And that's where an accountant comes in and tells us what that should be.
They tell us how long a life will be, how long it will. That's right. It's a wonderful it's a wonderful thing. The forensic accounting tables, isn't it?
And to that side of it, we also have a highly experienced team of personal injury specialists within the liability unit for Crawford's, led by John Van Wettering, who I think is on the call today, who would be best positioned to assist HBA or legal advisors for the insurer with inquiries in this regard. Going outside of Crawford's, looking at cause, it might be one to engage with a material chemist or a pool lining or pool rehabilitation specialist, because whilst the cost of replacing this pool might be upwards of $200,000, there could be a way you can patch this. Unfortunately, in the actual claim, there wasn't a patch available. This was some nasty stuff that ate through 3 layers and got all the way down to the fiberglass, and no one would touch it. It was also a near new pool, so you're not going to accept a patch repair. But getting someone in who can look at, here's the surface, here's the pool chemistry, here's what's going on in the water, because there could again be a contributing factor that, yes, this might react with the water and give off vapors initially. That would be something we discussed with the manufacturer and possibly put our chemist in touch with them to talk about. If it's meant to be vapors for 5 minutes, but we've had this go on hours afterwards, is that because there's something going on in the pool chemistry with the dosing of the pool water that's interacted with this chemical? And that's something that we can draw on. Crawford has prearranged relationships with a lot of industry or experts in various industries with competitive fees already agreed, so that we can call on a wider network of specialists to help with these sort of scenarios.
Perfect. Look, we're at 1:24. We've had some excellent questions on here, and I'm just checking here as to whether there's any further, but I can't see any at the moment. Can I just ask you both for any wrap-up comments, anything additional you'd like to talk about in relation to this circumstance? Then what I might do is give a little teaser for the topic for next time.
Oh, look, we could talk about this scenario all day, Nathan. I've got a lot of thoughts still running through my mind about what experts you'd engage, when to actually engage them, because I think it's really critical to understand at what point you get that evidence. Again, which goes back to the strategy of the claim, which needs to be, a constant thought process. A strategy to me isn't deployed at the outset and not reviewed throughout the length of the claim. So it really is making sure, and again, if you've got experts engaged, if you've got loss adjusters, if you've got legal, then it's really important to ensure that there's open lines of communication so that you're all on the same page, again, focusing in on best possible outcome, earliest possible time. So, and it's really critical, if I can say, to make sure that you do the correct investigations early, rather than, because the other thing that sometimes goes wrong with these sorts of claims is going down too many rabbit holes, which is probably what we haven't touched on today. And I suppose, being able to lean into claims experts and people who have a wealth of experience and knowledge around these sorts of matters is really of great assistance in seeking guidance into those sorts of strategies and actions, including what not to act upon.
And John, 30 seconds till the news.
I would just add on the site investigations and treating those not with just looking at this pool. With this claim, one of the things that really cracked it for us was going to this site and seeing that this lady had CCTV in her garden and hadn't clicked that would show exactly what the insured did. And we said at the time, can we see what's on those cameras? And sure enough, it showed the insured washing this stuff off into the pool, dipping their brushes in the pool to use to scrub this chemical on. And that was something we did describe in the risk profile section of our report, and really helped us avoid going down too many lines with the insured of what they did and what they didn't do, because we've got it on camera. Here's exactly what you did.
Fantastic. Look, can I just thank you both on behalf of everyone who's attended today? And we have, I got a little a ticker tape on the top as to how many attendees we've got. And can I tell you, we have the same number of attendees now as when we started. And thank you everyone for paying such great attention and working through. Thank you for the excellent questions. Thank you, Chrissy. Thank you, John. These things don't just happen on the screen. A lot of time goes into preparing for these conversations. I know you both have made it look very easy today, but that comes from the many years of experience that you've got. Awesome session. Many thanks, Nathan, Chrissy, and John from Anonymous. Thank you. And Joe's asked, are the details of this case publicly available? I doubt it. It's just something I think that we are talking about here internally. Next time we do this, I'm going to give a quick shout out, and we will probably email out to the mailing group a completely different scenario involving a Sydney hotel and a dance school that burns. And so look out for that in your inboxes. We're excited. We'll have a different team to answer your questions and talk about it, but we very much look forward to it. Thank you for your support of us. Thank you for your support of Crawford. And if there's anything we can do to assist any of you in your day-to-day work, please don't hesitate to be in touch with either any one of us or the team who you are familiar with at Crawford. Enjoy your afternoon. Thank you. It's an on-time performance.
Thanks, Nathan.